The Supreme Court, in more crazy news, says it will consider whether a 30-year-old federal law prohibiting people under domestic violence restraining orders aren't allowed to possess firearms. That seems like something that you probably shouldn't do. That if you beat women, you probably should not have a gun. But the case is brought by a Texas man indicted by a federal grand jury violating 1994 law prohibiting gun ownership by persons subject to a domestic violence restraining order. Zackey Rahimi was under a federal restraining order in February 2020 for threatening a woman with a gun. He was also involved in 5 shootings in December 2020 and January 2021. Rahimi attempted to dismiss the indictment against him, arguing it violated the Second Amendment. A federal district court denied his motion, noting that the federal appeals court upheld the constitutionality of the firearms law in 2020. Rahimi pled guilty and was sentenced to 73 months in prison, but appealed to the United States Appeals Court for the Fifth Circuit. After an additional review, the Fifth Circuit reversed the decision, saying the 1994 gun restriction for people was subject to domestic violence restraining orders violated the Second Amendment, as the government failed to meet the burden of showing that the law is consistent with the nation's historical tradition of firearm regulation. The justices will hear the arguments in its next term, which begins in October. The reason this is important is we saw from the Heller decision a couple of years ago that they established the Second Amendment as being an individual right, even though the Second Amendment says a well-regulated militia. The letter starts, those are the words to it, a well-regulated militia. The Supreme Court said, well, that doesn't count. The only part of that amendment that counts is where it says the right to keep and bear arms shall not be infringed. So if it says shall not be infringed, what this case is arguing, another one of those Trojan horse cases, is arguing that no gun law is constitutional. Doesn't matter if you are a woman beater, doesn't matter if you're a convicted felon, doesn't matter if you're a terrorist, that any gun law in America could be invalidated. So, Michael, I'm going to start with you on this. What do you think will be the consequences of the Supreme Court effectively invalidating every gun regulation if they rule in the affirmative on this case?
This is, Robert, this is dangerous. This is going down another slippery slope. We're already dealing with, 430 million guns in the country and a population of like 330 million people. You're going to have an increase in deaths from domestic violence. You're going to have an increase in women being killed, African-American women being killed, if the Supreme Court sides with this man here. So once again, this is why we have to be vigilant and really understand the law. And I would argue, I know a lot of people may say, oh, well, this is the white man's law, things like this. They may make those arguments. If they use the law to trap us, and, you know, I would argue we need to understand the law better than they understand the law, so we can disarm them of their weapon and try to utilize political self-defense and use the law to our advantage. But once again, this is dangerous, and this is why elections have consequences. Okay, not just the president, but also the U.S. Supreme Court as well. I mean, U.S. Senate, also the U.S. Senate that confirms federal judges, confirms Supreme Court justices. So we need to watch this also.
And Matt, on that point, if under the Heller decision, they ruled that the right to keep and bear arms is indeed an individualized right. And then you lay on top of that this, which may invalidate the regulation saying that, well, if you have a restraining order against you for beating women, that you shouldn't be allowed to have a gun. Will any gun law be able to stand constitutional scrutiny, or will we have nationwide constitutional carry?
Well, I don't want to be glib, Robert, but I think the ones that they think should be able to stand will be able to stand, and the ones they want to invalidate because it's politically expedient, they will invalidate. And look, I'm currently a criminal defense attorney, among other things, and I've been a prosecutor, and this is a huge issue in Texas, in South Texas, where I live especially. And what I think is actually interesting about this issue is that it implicates something far larger than just gun rights. One of the issues that criminal defense attorneys always, crow against is the idea that if you're under accusation for a crime, but you haven't been convicted yet, that none of your liberties should be curtailed in any way, right? So the idea that you shouldn't be able to wear a GPS monitor or do any other number of things because you haven't actually been convicted. But obviously, from the public safety standpoint, we allow bond conditions to be applied because we want to make sure people are safe when somebody is under accusation of a serious crime, particularly when they're under accusation of a protective order, because the way a protective order works in Texas is the judge has to find that there's credible evidence of domestic violence having occurred or that it will occur in the future, right? So what that means here is the idea that the rest of the bond conditions will be okay, but the one that implicates your Second Amendment right is going to be removed is an absurd outcome. The reality is you should not be able to have a gun if you're on, bond conditions or you're under a protective order for a serious crime. And I think we as a society just have to say there are some places where we draw the line. One such being, if you're an accused woman beater, you don't get a gun. Right? If you beat the case, then maybe we restore your gun rights down the road. But to cherry pick this as one of the things that is okay to remove as a curtailing of your rights when you're under accusation or under a protective order is really kind of absurd. And I do think you're right. I think it's going to mushroom to the other gun laws. And that's, again, why we need really meaningful legislative options. Because, look, I live 2.5 hours from Uvalde. And a year ago, 19 kids were killed in a school, and we have no meaningful gun control laws passed since then, right? But now we're talking about whether a guy who has a protective order should be able to have a gun while he's under accusation of having harmed somebody. I mean, it's getting absurd. We as a people have to demand that our representative government actually represents us and passes laws that matter, that keep us safe. And I think the Supreme Court ruling affirmatively in this case could be ruinous to public safety, to Michael's earlier points.
Kelly, can you talk about how dangerous this could be to women?
A lot, and I don't mean to, be flippant about it, but it is so scary to me that this is not only being presented to the Supreme Court, but ironically, even though it's being presented to the Supreme Court, which is a serious issue, that in itself implies that it's not that big of a deal for a felon to have a gun, right? And this kind of actually goes back to the last case, my point being regarding protected classes under constitutional law. With this case, it's almost as if the Supreme Court is saying that not necessarily felons, but gun owners are a protected class, and anything impacting gun owners should be held under strict scrutiny by constitutional law. That's crazy. That's insane, because it's not something that you identify with. It is not something that is innate within you to have a gun. It's not your skin color. It's not your gender. It's not your orientation. It's your right, and I say that loosely, to have something. And they are treating that right, again, I say that loosely, to have something, as though it is a state interest to keep. I don't even know where to begin with that. I don't understand. That is blowing my mind right now, and it is. I'm going to have to wait until it actually gets heard in order to parse it out and really see what the arguments are going to be here. Because if they go that route, that's crazy to me.
Well, as we've seen, this court in the last 2 days has done more crazy than many people can think of. And I think the danger that this court has created is this idea of the institutional legitimacy of the court is now so far in question. It's difficult to see how they can regain that. What is standing? Who knows? It's whatever they feel like it being on any given day. What does the Second Amendment mean? It says one thing, but hey, it's whatever we feel like it says. Remember when they talked about Scalia being a textualist, going back and doing a searching inquiry into what the founders believed and what the drafters said? We know exactly what the drafters of the 14th Amendment said because they were drafting it to remedy slavery, to deal with the discrimination against African Americans. July the 9th, 1868, they passed the 14th Amendment to help black people after slavery, and this court said, well, that same 14th Amendment can be used to keep black people out of college. So this court is not bound by logic. They're not bound by law. They're not bound by stare decisis. The courts had decided 25,500 cases in its history. It's only overturned that 250 times. The Dred Scott decision hasn't even been overturned by the Supreme Court. But in the last 2 years, they've reversed themselves on Roe, and they've reversed themselves on affirmative action. So this court literally rarely is legislating from the bench. And if they want to be legislators, then get off the bench, have your sugar daddy, Harlan Crow, or whoever else it is, and then run for Senate. But otherwise, be a judge.